All right, I said 12:02 and I'm a man of my word. So let's get this webinar started properly. Again, this is Ross. I'm with the Law Library, the King County Law Library. Very glad that you joined us today. Hello, I have my camera turned on now. So this is office hours. This is one of our new webinar series where, in the past I used to do substantive webinars myself, and I would learn as much as I could about a topic. But then during a Q&A portion of that hour, I would realize that I was at the very extreme of my knowledge. So I would try to have an expert join me for the Q&A, but then it became obvious that the Q&A period was the best part of the hour. So this one is all Q&A. So y'all have submitted questions ahead of time. We might have time at the end of the hour if we get through all these previously submitted questions that you could put a question in the question pod here, um, if you so choose, and we might not be able to get to them anyway. But anyhow, y'all submitted questions ahead of time, and we're going to do our best to answer all those in the 57 minutes that remain. A little bit about the situation going on here. We're using Adobe Connect. Adobe has different pods, and so you can see my face in the video pod. There's also an option where we might share our screen. So in any of the pods, if there was a screen sharing pod or my face, probably not, you could click on the bracketed square. There's in the upper right portion of the pod a rectangle with corners on it. That makes that pod go full screen just for you. So you could get a better view, if we're showing you a website or something like that, you can zoom in and read it yourself. There's also the Q&A pod. So if you have any questions, if you're having technology issues, Adobe Connect is kind of strange. Throw a question in there. One of my coworkers might be able to help. There's also the web links pod. So if we're talking about a website, and do our best to upload a link so you can just click through and take a gander. Okay, so that is enough for um, preliminary stuff. I want to introduce our esteemed panelists today. If y'all would turn on your cameras. The last time I did one of those, none of the experts turned on their cameras, and it was just my face the whole hour. It was very unfortunate. But today we have Evelyn and April on the call. Do y'all want to do a little introduction about yourself? You're on mute, Evelyn.
You would think after so many years of online. My name's Evelyn, and I'm an estate planning attorney in Seattle. I've had a small practice for about 10 years. Um, I've done a little bit of probate, a little bit of trust administration, not a whole lot of like Medicaid elder law kind of stuff. Some of the questions kind of um, centered around that stuff, but hopefully I can help out. But mostly just general estate planning.
And hi, I'm April. I'm also an attorney in Seattle. I also do estate planning and family law is the other thing that I do. I have just been in this field during the last year, so I'm newer to it. And I know that Evelyn is going to share a lot of her expertise as well. I also noticed that there's some questions here that sort of get toward something that lawyers would call Medicaid planning, and I don't do that either. So yeah, we'll talk about it when we get there.
We'll do our best. And I guess that's a good segue that my goal with this class is to provide as much legal information as we can. There's a big thing in the law library where we're not practicing attorneys. We can't give legal advice. We can give legal information. And to the extent that this hour, well, we have attorneys who can technically give legal advice. That's not our goal today. Our goal is to give you legal information. We're not trying to give directed, personalized strategies and whatnot. So y'all have submitted questions ahead of time, and I have rephrased some of them. Some of them have necessary backstory. Some of them I've culled the backstory and taken that out, and kind of just generalized them to be applicable and hopefully a good learning moment for everybody who's attending. And we have, I think, oh golly, 15 questions. So I think it might get might make sense to get started. So the first one's kind of a good layup, but what is estate planning, and is it something that you have to do, or can y'all talk a little bit about the basics here?
Sure. Do you want to go, April, or should I?
Go ahead.
Okay. So when I do an estate plan for somebody, I do a basic set of documents. Usually, like it's a will that tells everyone where you want your stuff to go when you die. Um, a general power of attorney, a general durable is a key word there. Power of attorney, which lets someone act for you when you cannot act for yourself. So the general one is the one that um, lets someone act for you in terms of financial affairs. And then there's the medical or healthcare power of attorney, which lets someone act for you and make medical decisions for you. Um, Durable is the key word because that is the thing that makes it last when you're incapacitated. If you don't have the word durable in there, then it won't have any effect when you're incapacitated. You can make them active immediately, or you can make them active upon incapacity. So, like, you might not want to give someone your financial power of attorney, like just for today, but you would want, like, say, a close friend or a spouse to be able to pay your bills or access your account in case you're incapacitated. And then the last general form that I do is the one of the questions was a living will or a healthcare directive, um, which tells everyone what you want to have happen if you are brain dead or in a permanent unconscious condition and you're unlikely to recover.
Oh no, we've lost Evelyn. Is it just me? April, do you
No,
see
we
Evelyn?
did. Oh, maybe I think she's maybe coming right back. I didn't see her for a second there, but her name is still on the list. But I can finish that up and say, yeah, I agree with her. There's the second part of the question was, do I have to do this? I mean, no, you don't have to. It depends a lot on people's circumstances and what they have going on. But doing estate planning, a lot of it really makes things or can make things easier for your loved ones when you pass or even before you die, with like Evelyn was saying, while you're incapacitated, having people who are already designated to handle your financial information and your healthcare decisions can prevent a expensive and sometimes complicated process of the court having to set up a guardian for you. So going through the planning process can be helpful for those moments toward the end of your life. And yeah, it's often a good idea.
Evelyn, did you want to wrap up your thought on life estates?
Sorry, my internet's a little bit. I re-upped it like during or right before this, so it wouldn't do that, but apparently it didn't work. But yeah, like if you don't have a power of attorney, like a general or financial power of attorney, if someone needs to pay bills for you and access your account, then they have to ask the court to grant a conservatorship, which means that there's a whole expensive legal process that has to happen for someone to act for you. If you don't have a medical power of attorney, then your spouse or your adult children or your siblings, like there's a list in the RCW. Those people can make decisions for you, but just general actions or like medical stuff that maybe isn't directly dealt with by bedside medical decisions, um, they can't act for you. So they need to maybe go through a whole court process for like a guardianship or something like that. So it's a lot more expensive if you need one and you don't have one.
Yeah. And actually, somebody I see in the Q&A, they asked for clarification on the durable power of attorney. They asked if that includes financial or is that a separate document?
A general power of attorney is like financial is another word for it, and then there's the healthcare or medical power of attorney. So it's usually two documents. You can combine them, but then it's a little unwieldy. So
I see. And so we've talked about wills, we've talked about power of attorney and healthcare directives. Are there any other estate planning? I know that there's a big one that a lot of people have questions about. Any other estate planning tools or instruments that you have in mind?
Well, I mean, yeah, like there are trusts. People always want to ask about trusts. Community property agreements is a way to get everything just passed directly to your spouse. Um, that's an estate planning tool. Those are the only things that come to mind.
Yeah, then
Maybe.
there's also just the general reminder that I always give clients about, a lot of things will pass outside of probate. If you have life insurance or other types of accounts or whatever that you can designate beneficiaries on, it's a good idea to know who you have designated it and update when you want or need to, because those things can pass on to the beneficiaries even without a probate process. And so it's just a good thing to like keep in mind, but not technically necessarily something an attorney would be involved with at this stage.
Yeah.
And
I'm
being aware of
actually,
those beneficiaries
oh, go ahead.
is really important, especially when like big life changes happen, like your children become adults, you get a divorce, your spouse dies, stuff like that. Like you want to check all that stuff when you have a big event, or every 10 years maybe as well. Sorry, go ahead.
Yeah. No, I just think I think we've so far kind of laid the groundwork for estate planning. One term that's come up, and I think there's practitioners on the call that this is going to be obvious, but some people maybe are just learning about estate planning for the first time or thinking about it. One term that's come up is probate, and that's the court process for granting, an executor the power to handle someone's estate after they've passed away. So some of our questions are talking about, before you've passed away. There are things that you can do estate planning wise. Um, Afterwards, some things become probate matters where the courts have to give someone power to move assets around. That can be avoided in certain circumstances, and that might come up later in the hour. But just so you all know what probate is, there it is.
Yeah. And
Um,
when you die without a will, it's called an administration.
yes.
You go through like
Uh,
a similar process wrapping up your estate.
yeah. And so we have questions about wills in the library often. And so wills we know are a way that you can designate who gets what when you pass away. Do y'all want to talk about wills generally, or before I get to these specific questions? No.
I
Okay.
think a will is pretty. I think people know what a will is.
Yeah.
Yeah.
So somebody
I
asked,
would
"What
say
is a living will?"
it's not a will. It's the healthcare directive that we mentioned earlier.
Yeah.
So I would say that I don't know if anyone remembers the Terry Schiavo case from back in like the I don't know 80s. It was a while ago, but a woman, I think she had a heart attack and she was brain dead, and her husband wanted to pull her off life support, and her parents insisted that she was not brain dead, and they wanted to keep her on life support, and it was this whole long court case. Like the courts got involved. It got like people at like the state government level, federal level. The president said stuff about it. It was a huge deal, and essentially that's why you would write a living will, because you want people to um, know to cut off artificial support for you if you are in a permanently unconscious state. Um, in my experience, 99.9% of the time, it's not going to be used in court. Like it's a legal document. So you would say that so that if someone sued and tries to keep you alive and you wouldn't have wanted to be alive, another person can bring that to the court and say, no, this person wants to have their support withdrawn. Mostly, I think the practical use for it is that so you are telling your family and friends what you want to have happen, and so they feel comfortable making that decision for you if you can't speak for yourself. Um, it's when you're in a like a terminal condition and you cannot speak for yourself. And then you need to have one doctor confirm it, because if you're terminally ill, you've been ill for a while, so your doctor is familiar with your situation. If you're in a permanent unconscious state, you need to have two doctors confirm it, because that's more like you had a car accident, or you had something where it was sudden, right? And so you had to have two doctors involved. And then you would still have stuff like artificial respiration, artificial nutrition, artificial hydration. Depending on your circumstance, you'd have something like dialysis on your list of stuff. And then I want to say one other thing. Oh, there's a do not resuscitate in there often. so you can take it out. And the other thing is that is usually in there is that you want to be given pain medication even if it hastens your death. So that's sort of another element of it. And again, it's to make people more comfortable, making decisions for you. You don't have to have one. If the people around you know what you would want, then it's okay. Like I said, it's often not brought to court. It's a legal document, not a medical document. So, or not a medical order. So like it's not something that your doctor signed. It's not a post. Yeah, I think that's most of what I wanted to say. Some people are very uncomfortable signing something like that, and that's okay. It's not. I think it's not super essential if you know that the people around you would do what you want them to do. So, oh, I remember. You can get a very good one free. Washington Law Help has one, and EOLWA, ILWA. They have a very good like combined healthcare directive and medical power of attorney document on their website.
Yeah, that's actually what I was going to say too. There's an organization called End of Life Washington that is a nonprofit that has a good standard form for this, and you just have to have 2 witnesses sign it. So if this is something you're interested in, separate and apart from the rest of the estate planning process, it's fairly easy to make happen.
Yeah. And that document was written by lawyers and vetted by other lawyers. Like it was really well done.
And I just threw that into the web link so y'all can open that up. And I also put Washington Law Help in there as well. So the next question, hopefully this is more will focused, is what is a pour over will? That's pour over like you might pour butter over your leftover rolls.
Yeah, so this has to do with, it would be something that you write, hopefully with an attorney's assistance, once you've created a trust or at the same time as creating a trust. And it essentially is a way for you to say, like, if you've created a trust, we will talk more about this as we go about what that is, but you're essentially transferring ownership of your property to the trust rather than you yourself directly owning it. And a pour over will is a way to, at the time of your death, have your will say, everything that has not already been transferred into my trust, I am pouring over into my trust. So at the time of my death, anything I haven't yet put in there should go in there. It's kind of like a backstop measure. But again, something that seems like complex enough, I'd recommend working with an attorney on it.
Yeah,
that makes sense.
Trust. I get very jumpy with DIY and trusts in particular. Yeah, so if you write a revocable living trust, where you put all your stuff in the trust for your lifetime, I think it might be malpractice for like an attorney to write one for you and not give you a pour over will. I'm not 100% sure on that, but I have a vague memory of reading that somewhere. So it's really, really important to have the pour over will. So yeah, like if you put everything into your trust, and then like April said, if you didn't think to put something into the trust, the pour over will put it into the trust for you. You might use one to avoid probate because you don't want it to pass through your will. But probate is not an expensive or particularly lengthy, like not necessarily lengthy process in Washington. So it might be introducing unnecessary complexity to your estate. It just depends on your situation. Like a lot of people do them in California because probate is really, really expensive down there because you have to keep going back to the court to ask them to do stuff. In Washington, in your will, there's usually a clause that says that you have your personal representative has non-intervention powers, meaning that they can, once the court gives them their letters, their authority, they can go and act and close out your estate for you and like do all the things. And they don't have to keep going back to the court to ask permission to do stuff. So it's not as expensive, essentially.
Especially when you buy the King County Law Library's probate kit for $30. Savings are to be had for simple probates. Okay, so now we're in trust territory. Do y'all want to talk a little bit about what trusts are just to lay the groundwork, or?
I think April did a pretty good job with the basics. I guess just to reiterate a little bit, like there's the grantor who puts money into the trust or assets, or it's called like the res. Then there's the trustee. It's like a triangle. There's like the grantor, the trustee, the person who has like legal title to the property, like they can decide what to do with it. And then the beneficiary who holds equitable title to the property. So it's their property, like they own it, but they can't make the decisions about it like the trustee can. There were a few questions, like they can be revocable or irrevocable, like April was saying. They can be often they're like generally it's inter vivos, like one that you make while you're alive, and it's modifiable, like it's revocable, or they're testamentary, where it's a trust that you put into your will, and it's irrevocable because it only comes into effect once you die, and once you're dead, you can't change stuff, so it's irrevocable. People might do them to avoid probate, but again, it's not super expensive in Washington, so it's not super necessary. Often people do them for privacy as well, because wills are a public record. They get filed with the court, and trusts are not, because stuff passes privately and directly to the beneficiaries.
That's great. As a follow-up, somebody asked, what is the difference between a trust and a life estate?
Oh yeah.
Yeah, so we were talking about this a little bit before we got on the call, but life estates, I mean, I will explain what they are, but I'll also say they're not used super commonly in Washington. I think you still can. It's just that it's just not like the preferred practice or a common practice right now. But basically, it's a situation, it's similar to a trust in some ways. Like a sort of classic example would be I might give my home to my adult child, but hold a life estate in that saying that I can continue living in the home for the rest of my life, even though I have given the home to someone else. So it's like a way to yourself not own the property while you can still remain living there, which is a similar thing to what some of the trusts do, where it's like technically the trust owns the property and you can keep using it, but it's technically not owned by you. And I think where I saw this come up in my, like, honestly, Google searching, because again, it's not that commonly done here, is apparently some people use it as part of a Medicaid planning process. But Medicaid planning is, in my opinion, fairly complex and specialized. And it's not something I do in my practice. And so if you're pondering that, I would suggest talking with someone who does regularly do Medicaid planning.
Yeah, it's an elder law attorney thing, and not even all elder law attorneys do that.
Yeah.
It's this morass of stuff. But yeah, it can be part of a Medicaid planning plan. I would add to that like they can essentially do the same thing, a trust and a life estate. You might also, like, say you have a second marriage and you want your spouse to be able to live in the house that you both had when you die, but you want the house to go to your kids eventually. So like your spouse would retain possession of the house, but they don't own the house, because they can't like, owning something is like you possess it and you can give it away, right? So you can't give away the house because you only have the life estate in it. And yeah, I think we just don't use them a whole lot in Washington. I asked around a little bit and I couldn't find anyone who does them. So I think maybe someone asked, like, why would you do a life estate over a trust? I think they can be less paperwork, because a trust is something that you have to manage. But yeah, but if you're concerned about your assets for Medicaid, doing something like a trust or a life estate can be a good idea, but talk to an attorney, because you don't want to disqualify yourself for benefits by giving something away too close to when you're going on benefits. And then honestly, I think the other, like with the spouse thing, I was thinking, I've had this before where you want your spouse to live in the house after you die, then the house goes to your kids. And at least with a few of the cases I've done, the couple has been married for 40 years and no one's worried about someone screwing over
Yeah.
their spouse's family. And so I just put in the will to spouse, and when the spouse dies, to other spouse's kids, and just kind of put that in both the wills. Um, and there's enough trust there. It's not legally enforceable. Like this, you can give it to one person, you can't give it to one person and then another person in your will. That requires trust. But if you write it down, then you're creating a plan with your spouse. And if there's it's a long-term marriage, there's trust, then I've been comfortable with that plan for some people.
Yeah, and something that you said, and I think that might come up again in the hours, that trusts are not really a DIY option, right? So people come into the library asking for trust forms, and there's just really nothing we can hand them in the library besides books, where you could essentially get a law degree and uh, learn to do this yourself. But it's not something like probate, where there are kits that you can do yourself. And because often money or property is on the line, this is where the expertise of a lawyer pays for itself. Just want to throw that out there. Um, so next up in Trust Town, no, what's
I
that?
was going to say one other thing. I was just looking at my notes. For a life estate and for a trust, if you retain possession, you have a duty to the people who are the remaindermen, the people who are the contingent beneficiaries who are getting it after you. So you can't waste. Like you can't destroy the property. You have to pay taxes on it. You have to pay for upkeep. There are a whole set of responsibilities. Like you can maybe rent it out, but not necessarily. So you just have to. Some of those responsibilities are laid out in the RCW. You might want to put those in in the terms of the trust, just to be really clear with everybody, like what the responsibilities are. And if you do give someone a property in trust, then it is a good idea to think a little bit about whether, say, your kids or your spouse can pay the property taxes on it or can pay for the upkeep. Because if you just give them that property without any means to take care of it, then you're just kind of putting them in a bad situation, and they're going to have to figure out something like how to handle it. So just that's another thing to be aware of with that whole thing. So okay, sorry, go ahead.
Yeah, and I would say along the same lines for any kind of trust. And again, I think this is one of the reasons why we don't recommend trying to DIY it, is depending on like what property is going into the trust and for how long and that sort of thing. You really need to be thoughtful about who you are naming as trustee and as like possible successor trustees. So that's the person, like Evelyn said, who technically holds the title to the property and can like make decisions about what to do with it. And some of that stuff is like really, like there's some important interpersonal decisions to be made depending on who the beneficiary is and what the property is. Like, are they people who get along? Are they people who you trust to take care of the property in a way that you would have wanted them to? Are they available and around? Like, there's just kind of a lot of different things to think about that make talking about your specific situation with an attorney who does estate planning probably a good idea.
Yes. Now, somebody asked this question that came in this morning. That's kind of sometimes I try to leave off backstory, but I think this one is kind of important to read it. Kind of granular. So they said that there's an inter vivos revocable trust, and they said, for example, called the Smith Revocable Trust. The name of it conflicts with the financial institution is saying that the title to the account has to be Smith Irrevocable Trust. So right now it's Smith's Revocable Trust. The financial institution is saying that actually it needs to be the Smith Irrevocable Trust. It's an inter vivos trust, though. So they said that they want to add language to the trust which indicates the name of the trust will be the irrevocable trust upon death. I guess the question is, does that sound good to you?
I mean, always it depends, right? Um, if the financial institution is acquiring it, then you're like you would have to figure out a way to do that. Um, I think the trust would become irrevocable anyway upon your death, because once you die, you can't modify it, so you can't revoke it. So if they want that term in there, that would be fine. Like it's revocable until death, and then irrevocable. Like that name change occurs that you're passing. That seems fine. If you make it irrevocable now, then you should recognize that it's irrevocable and that you would have a really hard time changing the terms or changing the beneficiary. Like you're giving up a lot of power and control. I will say that irrevocable, like if you do need to modify an irrevocable trust, we have a law in Washington called TEDRA, TEDRA, the Trust and Estates Dispute Resolution Act, where you can bring the trust to before the court and change the terms if you need to. And you have to prove your case. Like you have to say, like, well, we know that the decedent, the person who died, wanted this to happen with this trust, and it's not happening because of these reasons. So we need to reword the trust in this way, something like that. So there is maybe a way to modify. So I just want to say, like, when we keep saying irrevocable, like there is like a system in Washington for fixing mistakes or whatever. So.
Yeah, but I'll say TEDRA is seemingly at least a weekly topic in the library. It's a kind of hot topic, but there are not good resources for it out there, especially for self-represented litigants. And if you're in TEDRA territory, we tell people flat out it's time to talk to a lawyer because it gets pretty complicated, seemingly, to this librarian's eye. Somebody asked, how do you properly transfer assets into a trust?
Well, the first thought that I have is April was talking about probate versus non-probate assets. And so it sort of depends on the asset. If it's a probate asset, then you want to name the trust in your will to make sure that it goes into the trust. If it's a non-probate asset, then you have to name the trust on the asset or in the documentation for it. Yeah, like I think that's the big distinction for me: the probate versus non-probate. So non-probate assets, you might change the name on the account. If it's property, you might use a quitclaim deed, QUIT, quitclaim deed, to change the name on it and put it into a trust. Assignment of ownership rights, naming the trust as the beneficiary just on retirement accounts. Although putting retirement accounts into a trust is tricky and often not recommended. So if you think you might want to do that, please talk to a lawyer for that. Like there are books written on that specific topic. So that's not a layperson thing. Like I'm careful about doing that, and tend to try to avoid it. What a non-probate asset is anything that, like April was saying, passes outside your will. It's defined in the RCW. It's RCW 1102-00513. But if you Google definition non-probate assets RCW, like it's like the first hit, so it's pretty easy to find, and it's shortly a step out. Like we were talking about community property agreements earlier. Anything that passes under a community property agreement is defined as a non-probate asset because it's not passing through probate, like through the courts. It's just passing, like you don't have to go through a court process to change who the owner is. It's just going directly to the person because you've named them, right? Or like a transfer on death account, or if you have like that's one of the questions. If you have a transfer on death account, it should go directly to the other person and it should not have to go through probate. And that's like defined in the RCW. So anything with the right of survivorship is like durable. It's a term of art, meaning that whoever owns the property with you gets it if they survive you, right of survivorship.
I was pasting that RCW in there, and probate versus non-probate, just 3 letters. Did you say that the transfer on death deed to a residence is the residence considered probatable asset or non-probate asset?
I'd say always it depends. Like there might be something weird going on, but my like 500 level, above the ground answer would be non-probatable because transfer on death stuff is defined in the RCW as non-probate.
That makes sense. Well, often we get a lot of questions in the library about the small estate affidavit. So for people who are hoping to avoid probate, there's certain criteria you have to meet, like are the assets worth less than $100,000 and no real property, so no land or houses. The small estate affidavit is very attractive, but then we do have people ask, we've used the King County Law Library's transfer on death deed packets, only $30. Um, and at that point, if there's no house on the table and there's just, the one measly $10,000 JP Morgan account, that seems like small state affidavit territory to me, but I'm not a lawyer, so.
I agree. I got to help someone with a small state affidavit earlier this year, and it was kind of fun. But it's clearly set up for that kind of thing where there's just like a little bit of stuff to deal with. It's not super complicated. Washington Law Help has great information about it.
Yep. If you're asking, does the law library have a small estate affidavit packet? The answer is yes. It's $15, but quite frankly, I think Washington Law Helps is good enough for most people. But if you're getting into a situation where, like what's the word? What am I looking for? Oh no, my brain's shutting down. Non-testate. What's it called? What's intestate?
Oh, intestate. Yeah. No
when there's a no will in an intestate situation, our packet does a really good job of having a flow chart as defined by the statute of who gets what. And so if you're in that situation, our packet, $15 might make sense. Okay, so advertising hat off. So the next question is, when is a special needs trust necessary? Maybe we want to define that. And then when is it necessary? And then are there alternatives? Something that we've come up, that's already come up in the hour is talking about like SSDI benefits and things like that.
Yeah, so I guess one thing we haven't talked about that is kind of related is we talked a lot about trusts generally. The time that I do use them the most, most of the clients I've worked with so far have been in non-taxable estates, but is as a way to give your property to your kids, especially if your kids are still minors when you die. So you set up a trust by which, like, if both parents were to die while the kids are still under a certain age, the money goes into a trust. You designate a trustee to help manage it and decide when to send the money out. And then that's when the kids get the money, and then they might get, distributions from it, like at ages 25, 30, and 35 or something like that. A special needs trust is when your beneficiaries have disabilities that allow them or qualify them to get certain public benefits like Social Security payments and Medicaid. Those programs, kind of like we were alluding to earlier with the Medicaid planning, those programs have limits on how much a recipient can hold in assets at any given time. Like if people have too much money, they need to pay for their own care and they don't qualify for those things. So a special needs trust is a way to set money aside for a beneficiary who has disabilities to help essentially like improve their quality of life, but without disqualifying them to continue getting Medicaid and SSI. That's my high level answer. Evelyn, please fill in.
Yeah, I was just thinking, I want to say non-taxable estate means that your estate's lower than the threshold for your estate taxes, just so you guys know. So you're not going to incur estate taxes. And yeah, I mean, I would agree with most of that, or with all of that. A special needs trust is like it's specifically for disability or some other impairment. So someone who can't manage their resources, and yeah, you put money into a special needs trust for that person. They cannot access the funds themselves. You have to have a trustee, and it's not for general support. Like in the wording, like you can't say this is a general support trust. because it's supposed to supplement the general needs that the government is supporting with their benefits. And so, yeah, like April was saying, if you have a means test, if you're receiving means tested benefits from the government, meaning you're receiving them because you're of a certain income or you only have so many assets, then a special needs trust might make sense. I think with that question, the questioner mentioned SSDI. So that is Social Security Disability Insurance. That's for people who are disabled or their dependents or someone who's died and the dependents of someone who's died or retired. That is not a means tested program. So I would not go with a special needs trust, like, generally, high level answer. For someone on SSDI, you may not need it because your benefits aren't going to be cut off because of your financial situation. But if you're on SSDI and Medicaid, or and a means tested set of benefits, then it might be good to use there might be another reason to use a special needs trust. Or maybe you're just on SSDI. Maybe you would benefit from a trust that is not a special needs trust, but is a different trust that's specific to your situation. So there's a lot of stuff going on. What else did I want to say? Oh, there are a couple different ways to have a special needs trust. Or to create one. There's a self-settled trust. So someone who is disabled, but they say they received an inheritance. If they just receive that inheritance directly, they'll get kicked off their benefits until the inheritance has been spent down. So instead, you can they receive those benefits, and then you create a trust with their money for them that's self-settled. With those, often, I think it's required that when the beneficiary dies, the state is allowed to claim what's left in the trust for reimbursement. You can have third-party trusts. You can't just create one for it. It has to be like a relative or a guardian or something can create that for an individual who's disabled. And I don't think that is subject to estate recovery. I think that can go to a decedent. And there are also pooled trusts where it might make sense if someone's maybe lower income. You pool the resources with a bunch of other people, but then your individual has their money in a separate account within the trust, and it's run by a nonprofit. It can be a little bit more financially efficient. So
now there's another question that is very similar. So the well might have run dry on this topic, but just to be sure, someone said best option to leave assets to an adult disabled child while hopefully avoiding probate and those court mechanisms. So they said, is it a testamentary trust, revocable trust? And then they asked about how that might interact with SSDI. You did a good job with that, though.
Yeah, I think, so if they are disabled and on means tested benefits, then a special needs trust would probably make sense. So it would be a third party special needs trust. So again, I wouldn't write it yourself, but that is at least some terminology to, if you're calling around different lawyers to try to find someone to write that for you, then that's those are some of the words that I would use.
I feel like that's a huge battle in the library. I'm not a lawyer, so sometimes I'm like, what is the right term? And then once you find the right term, you can find your research jumping off point. All right, so now we're into the miscellaneous category. So this question, boiled down to its essence, is asking if you would address methods to provide life insurance for a minor.
Do you want me to start with it?
Yeah.
Yeah, I mean, I don't do insurance or sell insurance, so you could talk to an insurance broker about that kind of thing. Before you talk to someone, though, think about how much you can spend on it. Don't tell them how much you can spend on it, but establish that before you talk to somebody, and understand what you want it to be used for. I think the question mentioned an irrevocable life insurance trust, ILIT is the little acronym. I think you would use that mostly to, I've never written one, but I think you would use that to avoid estate taxes. So if you are not concerned about estate taxes, I wouldn't bother with it. In terms of life insurance, one thing I tell people is to make sure that you have a secondary beneficiary so that if you die, the insurance policy doesn't have to go through probate, because it'll have someone to go directly to. Life insurance is a non-probate asset. And what do I want to say about? The question asked about the child getting the trust when they reach maturity, and if the parent is still alive. Like, yeah, I think you would just name the kid as a secondary beneficiary. So I was thinking that you could. But the question asked, what can you do? Like, if you have insurance, life insurance for yourself, and you name the child's trust as a beneficiary, how can you make it go directly to the child? I think that, again, like, high level answer, not knowing your particular situation, you could say something like, the beneficiary is the Smith family trust for the benefit of my child until that child is 18, and then it will go directly to the child. You could just say that in the beneficiary designations, I would think.
Okay. And then this has come up already, but we've talked about the estate tax, but somebody asked specifically, how much of an inheritance is tax exempt, federal and state?
Oh, I was just looking at my notes. One other thing
Sure.
about trusts for kids, and April probably does this too. Like in a straightforward will, straightforward, but in a will for parents of children, usually you put in a trust so that the kids don't get money directly when they're 18. So like it stays in the trust for the kids, right? So you might write a trust, like all the assets go into this trust for the children, and then you would do some sort of like maybe a third of it goes to them at 22 when they graduate from college and they're moving, right? Then another third would go at 25 when the kids maybe getting married or another big milestone, and then maybe it pays out entirely at 30 when the kids having kids themselves, they're buying a house, that sort of stuff. So if you have a trust for your kids, just a family trust for your children, you can specify how, like, when assets go to the children, and like how and when, essentially. And that doesn't mean that the kids don't have access to any of those funds until they're 22, 25, and 30. It just means that in order to access those funds, they have to talk to the trustee, right? So they could be 20 and be like, hey, trustee, I need a serviceable car because I'm going to be doing this internship. And the trustee would be like, yeah, I think your parents would support that and pay for the car. So I just kind of wanted to mention that as well. Like, it's not just like money goes to the kids. If you do die without a will or a trust, and you have kids and the money goes directly to the kids, kids are not allowed to own property. So it would go into a trust written by the state under UTMA, the Uniform Transfer to Minors Act. So the state would put it into a trust for the child. And when the child is 18 or 22, if you've referenced UTMA in your estate planning documents and specified, the state would hold on to the money through a trust and give it to them when they're 18 or maybe a little older, depending on circumstances. So, sorry.
Yeah, and this is another place where, again, like thinking about who you name as trustee really matters, including, like, a lot of times I advise people that they would want to name someone different as the trustee over the finances that are being held for the kids' benefit than the person who they have named as the kid's guardian. And that's just, like, you really want to think about who those people are and, like, can they work together, but also by, like, sort of separating out those roles, for some people, and you might not have any concerns at all about whoever you name, but for some people, it's like a way to ensure them, like, oh, then the guardians are less likely to misuse the funds because there's an outside person who's like the trustee over the finances. But it also, adds in some logistical hiccups because then the guardians have to work with the trustee to actually get the money. So, there's a lot of things to consider, but it's important, and you can do a lot of, like, tinkering and tweaking to make it fit your needs. Like, if you're someone for whom it would be fine with you for the money to be spent on college, but it would not be fine with you if your kid decides to like take a gap year. Like you can be really specific about how you want the funds to be administered. Sorry, I just started getting a feedback, so I'm going to hit mute for a second.
Yeah, I got that too. Hmm. All right. So the next question is, how much of an inheritance is tax exempt?
All right. Yeah. Sorry. Let's see. Oh, and I will say, like, just tagging on to April, I've had plenty of people to say, like, I want my sister for both. Like, it can be okay to name the same person. The example that I always use, though, is that if you're worried that if the person's the guardian and the trustee, they could use the money to build an extra room onto their house for your kid, so the kid has their own room, which is a reasonable thing to do with money. But then the money's not there for the kid later, and they've increased the value of their house with that money. Maybe there's no bad intent, like it's perfectly reasonable use. But if you have a different trustee and guardian, then there's some checks and balances. So the Washington State estate tax is $2.193 million. Above that, Washington State's estate tax is progressive. So for the first million above that, it's like 10%, and then the next like million and whatever, it's like a higher percentage. It increases until I think 20% is the top. It hasn't increased since 2018, which is kind of funny because the law specifies that it's correlated with the consumer price index for the Seattle, Tacoma, Bremerton area, that area. And in 2018, the federal whatever agency, they stopped calculating that price index. They changed it to Seattle, Tacoma, Bellevue. So the legislature needs to change the wording in the law to change the estate tax. So for the time being, it's 2.193, and that isn't going to change until they change the law. So yeah, if you have, like, say, a $4 million estate, what you would do is put everything over 2.193 million into a credit shelter trust for your spouse. That's one thing. Maybe it's not a good idea. It depends on your situation. But one thing that people do sometimes is put that extra money into a trust so that when their spouse dies, they don't have a $4 million estate. They have a $2.193 million estate, and all the extra money that was the spouse's is in a trust and passes directly outside of probate and doesn't incur estate taxes. Well, not outside of probate, but it doesn't incur estate taxes. The federal limit is 12.92. So it got increased in, I want to say 2017. It was 5 million and then went to 10 million. And it's linked to inflation. So now it's gone from 10 million to 12.92. And then in 2025, that's going to sunset. So it goes back to 5 million, but then increased for inflation. So it's going to go back to, I don't know, maybe 6.8. So yeah, you have to have an estate that's more than, right now, $12.92 million to incur federal estate taxes. So if you're incurring federal estate taxes.
And Evelyn, man, I'm getting the feedback again, but remind me, it counts everything to determine these amounts, right? Like life insurance, house, like
your whole estate, even property that's outside of the state.
Yeah.
I mean, maybe I'm remembering something wrong, but that's what I remember. What did I say? Oh, the other thing is that for a married couple, there's what's called portability. It's another term of art. That means that you get 12.92 million each as like a team. So if you've got $24 million and the first spouse dies, they don't incur any estate taxes for their half of the 12 million, like their community share, and they leave it to the spouse. When the spouse dies, they get to port the estate tax limit from their spouse who passed away. So that second spouse, if they have an estate of 20 million, even though it's above the federal limit, they don't incur any federal taxes because they can apply their deceased spouse's credit to that. Now, if they remarry, that changes, or it can't. Like, no, I think it definitely changes. So be aware of that. There's all sorts of there's always like a but this or a except for that or whatever tax. And I'm not a tax person. I just know like some of the basic stuff that you need to know for estate planning. So yeah, and there's no portability for Washington State estate tax, which is why some people will do a credit shelter trust in their will.
Okay, we got 3 minutes left and 2 questions. Somebody asked, what happens to jointly held bank accounts after one person dies?
It should go to the survivor. That there should be a right of survivorship on that, so it should just go to the survivor. One thing to watch out for that is that a lot of, I mean, and maybe I'm wrong. There's always a depends or a caveat, but oh yeah, the one thing that I was thinking about is that if you're an older person and you put your kid's name on the account with you to help you like pay bills and manage your affairs and everything, if you then die, your kid inherits that account, and then like maybe your will says split everything equally, but that account went to your one kid, so it won't be controlled by your will. So you're like the one kid on that account might receive more than the other children, which can create some dissension. People are not always at their best when a parent dies. So it's a good thing to pay attention to if you are an older person and you have an estate plan and you do that. So.
Okay. And, with 2 minutes left in the hour, the one question that's in the Q&A pod that I think is worth asking, how do you find a competent lawyer to help you with a trust?
Oh, April, do you want to? I would say ask a friend. If you have someone that you know who's worked with somebody that they liked, that's like I would ask around to get a personal recommendation. That's one thing I would talk to or suggest. Another thing is definitely talk to a couple people. Like, don't just go with the first person you talk to. And, trust your gut. If you're talking to somebody who's throwing out a lot of terms you don't understand really, really fast, not explaining things very well, maybe don't go with that person if they're not able to explain stuff to you effectively. I would go with a lawyer, not a binder that you buy at like Office Max or whatever. Like you can buy estate plans online for they're often not tailored to a particular state's laws, despite what they say, and you can be creating more problems for your family than solving with that kind of thing. It'll come in a really nice binder, but may not do what you need it to do. So.
Yeah, the things I would add are some people have through their employer access to legal services. Sorry, it's talk with this echo. I'm not quite sure why that's happening. Can you hear it, Ross? Yeah, Evelyn cannot hear. Maybe if you mute for a second, Evelyn.
Yeah. Oh, maybe it's my phone.
Okay, let's see. Oh, that's better. Okay, so some people have through their employer access to to legal help. Like it's often an insurance policy. I think most Microsoft employees have it, and some other people. So you probably should check through your employer's benefits to see if you have access to something like that. I agree with Evelyn, like asking around, asking your neighbors, and feel free to just reach out to different attorneys. I think Evelyn's advice is solid. I mean, you deserve to work with someone that you're comfortable with. And I think if you give some really basic information to the office of various estate planning attorneys, like they will have a pretty good sense right away if you're a good client for them or if they should send you somewhere else. So yeah, I'd say reach out to folks and ask for some initial help or see if they might be available. King County Bar Association also has a lawyer referral service you can use. It's It's as far as I know, I think kind of randomized. Like lawyers can sign up to be part of this referral list, and then if you contact them and ask for an estate planning attorney, and they will assign you someone that you can reach out to and meet with. And then if that doesn't work, you can ask again, and they'll assign it. There's a process on kcba.org, so that's another possibility.
Okay,
I
great
had one other
information.
thought.
Oh, go ahead.
Just I mean, like the word of mouth thing is good. I haven't looked at my website in a really long time because I mostly just work on word of mouth stuff at this point. Um, so I think that can be a really strong factor. But I was also going to say that if you know a lawyer, your lawyer friend went to law school with people, and they have people they like. Lawyers love networking, and keeping in touch with their little lawyer friends. So just if you know someone who's a lawyer, that might be a good person to hit up for a suggestion. Like if I was going to get a divorce, I know exactly who I would call. So
All right. Well, thank you so much today.